It's still 10 o'clock.
Good morning, everybody. We're getting started here in about 9 minutes. It's cold out.
I know. My rain jacket.
Yeah.
I just got one like a couple months ago. It's great.
Good morning, Sam. How are you?
I'm good. Good morning. How are you?
I'm good, thank you.
I am running around like a madman.
What was that?
I'm running around like a madman this morning as usual.
That's okay. Hey, any day above 6 feet is a good day.
Right. I like that attitude. Okay. Nobody wants to be on video this morning. Okay.
the policy is going to start decreasing in value.
T minus about 4 minutes. Can everybody see my slides?
I can, yes.
Beautiful.
Okay,
That's a yes.
All right.
yes.
Thank you.
Yes.
Yes.
Okay. Awesome. All right. Hope everybody is having a good morning.
Morning, Sam.
Good morning, Sam.
Morning, Linda. Two Lindas. Maria, how are you? I still have
All at one time.
Yeah.
All right. We are about 3 minutes away from starting. People are still joining. We have 206 registered, so I'm gonna give people a minute to sign in before we get started. One of my processors made Cuban coffee this morning, so if I talk fast, I apologize.
That's not like mud, is it? Like Turkish coffee?
It's not quite Turkish in terms of the grounds are not in it, but it's pretty good. Okay. Good morning, Birgit. I see I've got some legal resources people on the call. This is like fancy now. Uh-oh.
Morning, Sam.
I hope everybody is doing well. We are about 1 minute away from getting started. Okay, everybody, it's 10 a.m. I like to get started on time. I don't want to waste your time. I want you to learn about Homestead. So we're going to go ahead and get started. I want to start off by telling you, if you have questions, you can type them in the chat, or you can just unmute yourself and ask me. I've got pretty much everybody on mute, but I don't mind you unmuting yourself and asking a question. You can interrupt me. This presentation is a little on one of my shorter presentations, so probably about 30 to 40 minutes at the most. Homestead, what the realtor needs to know. The purpose of the presentation here today is to get you information that you can give to your customers about Florida homestead. I am an attorney, so we're going to start off with a disclaimer that I'm going to be talking about homestead, but this does not create an attorney-client relationship. If you have specific legal questions, you can always call me and we can set that up and we can answer your questions. Just a little bit about my firm. It was founded in 2007 and we focus on real estate and business law. We are dedicated to helping small business owners, entrepreneurs, buyers, sellers, and property managers with their legal questions. And I want to make sure that I tell you, as realtors, you are small business owners. So make sure that if you have any questions about your business, your Chapter 475, setting up LLCs, things like that, you can always give me a call. And I'm happy to walk you through that and discuss your needs. We have offices throughout Southwest Florida. I need to update my slide here because we have an office in Cape Coral. And a little bit about me. I've been an attorney now for almost 18 years, and I specialize in real estate law. I serve on the NABOR Legal Resources Committee and the Real Property Probate Trust Law section of the bar. And I serve on the Real Estate Industry Liaison Committee in that section. So I help draft the FAR bar contracts. Actually, what we do is we review them after they're drafted by a secret committee. I'm a recovering politician, so you have to excuse the jokes. I am remiss for jokes. And today we're going to talk about homestead, and we're going to dive right in with ad valorem property taxes. So let me just start before I even talk about ad valorem. There are basically three homestead protections in the Florida Constitution: ad valorem property taxes, asset protection, and descent and devise. And we're going to touch on all three of them, and we're going to talk about federal tax law a little bit at the end. So starting right off, ad valorem property taxes, these are property taxes, and how do we save taxes for homesteaders? So a few basic points. The tax system in Florida is great. I personally think it works really well. It's a little convoluted sometimes, and we do call the homestead law the legal chameleon because it always seems to be adopting and changing to circumstances. But in terms of just getting the taxes assessed, all county taxes, property taxes are assessed on January 1st of the year. Then approximately August, after they have gone through and assessed all of the property taxes, the property appraiser sends out the notice of proposed property taxes. This is your trim notice, your truth in millage notice. And you have an opportunity then to review that and rebut any assessments by going to the VAB, the Value Adjustment Board. That process is in August and September. And then after the government sets their budgets and their millage rates, what they're supposed to do over the summer, the information goes from the property appraiser to the tax collector, who sends out the tax bill on or about November 1st of each year. And then, of course, property taxes are due March 31st of the next year, and you get your discounts for paying early. Property tax bill comes November 1st, you get a 4% discount for November, you get a 3% discount for December, a 2% discount in January, a 1% discount in February, and if you pay in March, you pay the full amount of the property taxes for the year, for the previous year, and they are late April 1st. So the biggest thing about the property taxes is you want to make sure that your customers know to get them paid, and you want to make sure that they get it registered on time, which is by January or by March 1st. So talking about the homestead exemption, you know, a person who owns the property on January 1st, that's important. On January 1st, you have to have legal or beneficial title to the property, and you have to have a good faith belief that it's going to be your permanent residence to get the exemption. Christian, is there a problem with yours? Let's see. Yanley can't hear me. Can everybody hear me? Shake your heads. Okay. Some people are having issues, but all right. So once you make it your homestead on January 1st, by January 1st of each year, you're entitled to reduce your assessed value up to $50,000. But it's not a simple $50,000. You get your first $50,000, first $25,000, and your third $25,000 of value off. And the first $25,000 comes off the entire bill. The second $25,000 only comes off of the county taxes, not the school board taxes. And of course, to qualify, you have to be a permanent resident as of January 1st in the year that you apply for the exemption. You may file your homestead exemption prior to January 1st, but you must do it by March 1st. So what does that mean? Say you close in July, and you get your paperwork, and the deed gets recorded, you get your driver's license changed over, you get your car tags changed over, you get all your stuff, you're moved in, you've got your utility bills, and you're in the property. Say it's August 1st. You can go on August 1st and apply for homestead for the next year. And what that means, what happens is you will pay the tax bill in November based on the seller's homestead status, and then you will get your homestead status in the next year. And by the way, it's per family unit. So I had a question about, somebody asked me if we can split homesteads, and I think they were asking in a divorce situation. If you are a married couple, and Florida does not recognize separations, you are either married or single in Florida. If you are a married couple, you cannot, quote unquote, split the homestead. It's per family unit. And Collier County in particular is very strict about this. And all the property appraisers check. So, I know we have agents from all over the state on this call, but all the property appraisers check with the northern states, and they confirm that you are, in fact, homesteaded in Florida, because it's a lot of money to the county off of your tax bill that they want if they can get it. And that's just the nature of government. Moving right along. So before I move along, does anybody have any questions on this? First and third, $25,000. It's a $50,000 total. Yes, Leslie, we're going to send out slides and a copy of the video afterwards. You must be in the property by January 1st. And it applies to your family unit, and you have until March 1st of the next year to apply. How do you apply? You have to have evidence of ownership. You need a recorded deed. You need your social security numbers. If you vote, you need your voter registration done by January 1st. You need a Florida driver's license dated prior to January 1st, and your vehicle registration dated prior to January 1st. And then as an option, which a lot of people like to take advantage of, you can declare your domicile by filing a declaration of domicile prior to January 1st with the clerk of the circuit court. If there may be additional information that the property appraiser requests of you, if you're not a US citizen, they're going to want to see your resident alien card.
Sam, do you need all of those documents, or?
You need all of them, Jason, yes. You basically have to prove that you are who you are and where you live with all of those documents. It's in some counties Lee County, for example, allows online registration. Collier County, you have to go in person with all this paperwork to get it done. Let's see here. Lisa is asking, my brother-in-law is telling me he only received 25,000 as property taxes this year. There must be something going on there, Lisa. Send me an email afterwards and I'll take a look at your brother-in-law's tax bill. So if your property is in a trust, and again, this is a difficult situation for some people if they've got a complicated or large trust, you have to bring in a complete copy of the trust agreement because the county wants to verify that you have not converted the property from real property to personal property, which sounds strange, but in the land trust statute, that's allowed. The beneficial interest in the trust can become a personal property interest, which would not be homesteadable. If you are if they have evidence that you are benefiting from an out-of-state exemption, you're going to have to produce documentation that you have waived that exemption and it's been removed from your property up north. So that's a big issue. Biergen, if one person is a U.S. citizen, you should be able to get homestead. You should. It just depends on the mood of the appraiser on that day. The other part of homesteading is, before I move on, does everybody have questions on documentation? What it takes? Okay. So the other part is save our homes. This is a huge amount of money saved by the taxpayer over time. So there was a constitutional amendment passed in 1992, starting in 1994, that says if it's your homestead, the value of the property cannot go up by more than 3% or CPI, whichever is less, from one year to the next. Right now, in a high inflationary environment where they're saying inflation is over 7, this is a big deal. If the CPI is 7 and your property taxes are only going up by 3, that's a good deal for the taxpayer. And it only applies to residences that are homesteaded. If you're not homesteaded, by the way, there's another statute that says it can only go up by 10%. So there is a little bit of a break there, but with taxes going up every year and the CPI going up right now, having homestead in Florida is a big tax savings or big dollar savings. Now, the cap does not apply to new construction on previously non-assessed improvements. So if you go pull permits, the county appraiser will see those permits. They will know that you have improved the value of your home. You'll be taxed on the value of the improvements, even if you're homesteaded. So does that make sense? When you buy a piece of vacant land, the taxes are going to be, a few $100s, and then you're going to build a big, beautiful home on it, and the taxes are going to go up, and they're going to be a few $1,000s after the assessor reassesses the next year. So now when you sell the property, that's when the assessor reassesses the property. I keep saying assessor. The appraiser reassesses the property and it goes to full market value, and the process starts all over again. If the buyer has got to make it their homestead, then the 3% cap starts with the new purchase price, and it goes up slowly from there. Does anybody have any questions about Save Our Homes? Yes, Katya, CPI stands for the Consumer Price Index. It's put out by the Department of Labor every month, I believe they put it out, and just let us know how it's a measure of inflation.
Sam, I don't know if you're watching the raised hands or do you prefer the questions typed?
Just shout them out, Marcia. Go ahead.
Okay, so I'm sorry I had a minute or two lag in logging on. I didn't catch the first 25 and the third 25. I know you get that sorry, the 50,000 exemption,
Sure.
but what does that mean, first 25 and third 25?
Okay, that's a great question. I'll back up so everybody can see that.
I apologize for that.
Oh, no, it's fine. The property value, you say it's $100,000 piece of property. The first 25,000 you get off your value, so it's 75,000. Then they tax the next 25,000 at full value. Then the third 25,000 they tax they reduce just the property taxes, or I mean the county property taxes, but you pay on the full value for school board taxes. So,
Okay.
so if the property is worth only 50,000, and maybe this other person who asked about their brother-in-law in the chat, maybe their property value is worth less than $75,000, so they're not getting the full value of the homestead. Because if, say, your property is worth only 50,000, then you would get the first 25,000 off, and you would pay taxes on the second 25,000, and there'd be no value for the third. So that's how that works.
Thank you.
You're welcome. Okay. Other questions? Let's see here. I'm seeing them in the chat. If you already have a Florida residence, purchase a house in November, but didn't change your driver's license until February, can you still apply for homestead? So Rebecca, yes, you can apply for homestead, but you're going to miss a year. You skip a full year because you didn't have your driver's license done prior to January 1st. And so you didn't have proof of homestead as the county appraiser requires prior to January 1st. Then Deborah is asking, can a couple have one homestead for one spouse in Florida and one homestead in Pennsylvania for the other if they are married with tenants in common ownership? Deborah, that's an absolute no-no. The county appraiser will find you, they will fine you, and it's very expensive. So do not do that. You either are Florida homestead or not Florida homestead with your family. It's the family unit. Other questions before I move on to portability? Save Our Homes, Debbie, shows up on your taxes in the form of it's a reduced amount. It should have the just value and then the Save Our Homes value on the tax bill. I think if you go to the property appraiser's website, it will show that as well. So portability. Portability is great. If you buy a piece of property in Florida and you homestead it, and then you go move to a new home in Florida, you can port your homestead with certain limitations. If the market value of your homesteaded property is going up, you can take up to $500,000 of Save Our Homes exempt value with you. So I don't do math. I apologize for those of you that are good at math. I am not, so I don't even attempt the portability calculations. I would have you go to the property appraiser and have them calculate it. But if you're going up in value, you can take $500,000 with you. If you're going down in value, there's a fairly complicated formula that they use to create a ratio for your current market versus your property versus your old property. And what I will tell you about portability is the most important thing is that you tell the property appraiser, go to the property appraiser and ask them what your savings is going to be. And they're very helpful. You can call them, especially in Collier. They will walk you through the process and show you the calculation. Elizabeth is asking, a child is on a deed and the parents claim homestead. Can the child claim homestead on another Florida property? If they're a minor child, Elizabeth, they cannot. Okay. Other exemptions. So there are, or Renee, before I move on to other exemptions, Renee is asking, their husband and wife are divorced. Can each buy a new home and how does portability work? Renee, that's a great question. If a husband and wife get divorced and one or both of them buy a new home, I don't know the answer. I would imagine it would be, they would split the value of the portability if the appraiser lets them. That's a great question. I'm going to ask the appraiser that and come back to everybody on that. Let's talk about other exemptions. If you're a senior citizen, you're over 65 and you earn less than $31,100 per year, and the county or the municipality that you're in has a specific ordinance, you can get a discount on your taxes. If you are a veteran, there are many veteran disability exemptions and you have to go and apply for them. For disabled or blind persons, there's a $500 exemption. And then there's a widower exemption up to $500. And nonprofits don't pay taxes on their property taxes on their property, provided they meet the definition of a nonprofit as defined by Florida statute. Debbie is asking, Save Our Homes. If you're homesteaded, Save Our Homes is automatic. And Elizabeth, I think I just answered that. If an adult child is on a property along with their parents, they should be able to claim homestead if they also own another property outright. That should not be an issue, although the parents' homestead may be reduced by a third. And then Renee, they usually it's one exemption is what you qualify for. Okay. Losing your homestead. So as I discussed earlier, you must have the property as your permanent residence as of January 1st to be eligible for homestead. And you inherit the homestead exemption for that year. So when you buy, say you bought in March and the seller did not have homestead, you would not get homestead on your tax bill in November. But if you apply for homestead prior to March 1st of the next year, you would get homestead in the next year for you. If you don't apply the and it was homesteaded, the homestead would be automatically removed because the property appraiser will have seen this deed of selling the property and they will automatically remove the homestead. So if you've not applied, then you would lose your homestead status. If you are no longer qualified for the exemption because you have moved or some other life circumstance, you must notify the property appraiser. You have an affirmative duty to notify the appraiser. If you no longer qualify and you don't notify them and you take the homestead deduction or exemption for the next year, they can look back as far as 10 years. You pay 50% in penalties and 15% annual interest. So it's a very expensive process to lose homestead and be dishonest about it. They as you can imagine, they strongly discourage that. Okay. So I get a lot of questions about what happens for rentals. If you rent your homestead, it's abandonment unless it's for less than 30 days in each of 2 calendar years. The other thing is, it's the character of the homestead on January 1st that counts. So don't rent your home on January 1st. If you do short-term rentals, don't rent it out for New Year's. If it's rented on New Year's, technically, you're not allowed homestead for the next year. So rent it out January 2nd, December 31st, but be in the property and own it and live there on January 1st. If the abandonment does not affect, if the abandonment is after January 1st of any year, it does not affect the homestead exemption for tax purposes unless the property is rented for 30 calendar days in 2 consecutive years. So if you're one of those people who perpetually rents your home for like Airbnb, you're not going to be able to get homestead if you do it for more than 30 days in any calendar year for 2 consecutive years. Questions about rentals? Elizabeth is asking, how many years does a homestead owner have if they sell to transfer their portability? That's a good question as well. I've seen portability go out as far as 2 years. And I would be very careful about that. The property appraisers, particularly Collier, are very conservative. and you want to make sure that you get it as soon as possible. One thing I'll mention about your question, Elizabeth, I know this from Florida case law. If you were to sell your homestead here in year one, and then you go out 2 to 3 years and you haven't bought a new homestead, but you kept the proceeds of the sale in a separate bank account labeled homestead property proceeds or something like that, the courts have said you don't have to immediately transfer into a new homestead as long as the funds are segregated. I don't know if the property appraiser would recognize that or not. Patricia is also asking, what if you live in a duplex on one side? So usually duplexes have 2 property tax identification numbers. You could take your homestead on your side and you would pay full value on the other side. If it's one property and you are allowed to rent out like a bedroom and maintain the character of your homestead. It's all a facts and circumstances test. So they look at, did you rent the whole property? Did you rent one bedroom? How much did you stay there? Stuff like that. It's a facts and circumstances to determine if you've lost the property has lost the character of a homestead. Aaron is asking, if you were added to a deed to an existing homestead, does it change the taxes? If you are added to the deed and you live there, it shouldn't change the taxes. If you don't live there, then you could reduce the amount of homestead. They could split the property if you didn't live there and you were added to the deed. I hope that makes sense, Aaron. Okay. Other questions about homestead taxes before I move on to restraints on alienation? Okay, restraints on alienation. Can you sell your homestead without spousal joinder? Do I have to have my spouse sign the deed? This is a question that I get at least once a week from realtors and customers, clients asking about their homestead. Somebody's moving and somebody's going to be out of town, who has to sign? And it's pretty simple. If there's one spouse on title and the buyer is buying a second home without their spouse, she has to join the mortgage. If you're a married seller is selling a second home and there's non-homestead language on the deed, this slide to fix this slide. The wife does not have to sign second home, non-homestead language on the deed. If you're selling your homestead, the spouse signs. If both spouses are on title, both sign. If both buyers would also sign the mortgage, even if only one spouse is the borrower, and all sellers sign on the title. And remember, there are only married and single people in Florida. I said this earlier. There's no separation. So if you're married, plan on your spouse signing unless it's a second home and we put non-homestead language in the deed. Okay. Any questions about that? Okay. Can one spouse waive their rights? So there's a new statute in Florida, 732.7025. I've copied and pasted it here so you can see it. And this has not, to my knowledge, been tested in the Florida courts yet, although it seems legitimate that your one spouse can sign the deed and waive their homestead rights, so that when the other spouse goes to sell, this spouse who is waived does not have to sign. Like I said, this has not been tested in the courts, but it seems pretty legitimate, and all the lawyers that I've spoken to seem to respect it. So here's a few examples about signing and moving. So we just got married and she moves into his house. It's homestead, they're married, they both sign, even if only the husband is on title. Again, we just got married, it's a second home, and he signs a non-homestead, he signs a deed with non-homestead language in it, or both spouses sign. What happens when you're getting divorced? You both sign. If you're not speaking to your spouse and you don't know where they are, they've gone south to South America, which seems to be happening a lot lately, or they don't like you and they moved away, you have a problem and you probably have to go through a partition lawsuit. And it can be very difficult, especially if we can't find the spouse. You have to get a guardian. It's a process that you have to go through. What happens if we are divorced? If the spouse signed a quitclaim deed, or if the divorce judge specifically awarded you the property in the divorce judgment, then you should not need your spouse to sign. This is incredibly difficult for people to understand and comprehend when they've just gotten divorced and they're trying to sell the property and they're not getting along with their spouse, ex-spouse. And divorce lawyers routinely screw this up. If the marital settlement agreement says spouse A, husband gets the property, then that marital settlement agreement needs to be incorporated into the final judgment of divorce, and it needs to use the magic words convey. Wife conveys the property to husband pursuant to the marital settlement agreement, something like that. If the magic words are not there in the marital settlement agreement or the divorce decree, then the other spouse has to sign, and that always causes an issue. Typically, what happens in a divorce is the property is awarded to one spouse, the other spouse will sign a quitclaim deed as part of the process, and the property will transfer. Where this gets messed up is when there's a mortgage on the property and you can't get the spouse who didn't take the property in the divorce off the mortgage without a refinance, and the spouse who's going to maintain the property doesn't qualify because they don't have enough income without their spouse. In that case, a lot of times the property is going to have to be sold. Questions about that? Yes, Birgit, it's even more fun when divorce sellers are foreign nationals. That makes it all the more interesting when you have to go to Brazil, or I didn't have to go there, but deal with Colombia and even in notaries and all that sort of thing overseas. And Birgit's, of course, German, and German notaries have their own fancy way of doing things. Okay, let's talk about asset protection for your real and personal property. This is great. This is why Florida is awesome in terms of its asset protection. We are probably the safest state in the country for property. This is the homestead exemption in Section 4 of the Florida Constitution. I'm not going to read it to you. I'm going to summarize it for you. Basically, pay your taxes, pay your mortgage, pay your contractors, pay your association assessments, and you can protect your homestead up to 160 acres in the county or a half an acre in the city. And just be careful, if you live in City of Naples, City of Marco Island, Everglades City, Fort Myers, Cape Coral, those are cities, quote unquote. If you live in Lehigh Acres, Golden Gate Estates, Ave Maria, those are the county, separate from the city. So you can have larger properties, even though people will address Ave Maria as if it were a city on their postage. It's not, and neither is Lehigh Acres. Okay, questions about that before we move on to federal taxes? We're almost done here today. Okay. So you can save capital gains taxes with your homestead. That must have been your principal residence in 2 of the last 5 years, which basically means you have 3 years after you move out to sell the property and not pay taxes. Individuals get up to $250,000 of tax-free gains. Married couples get $500,000. Any questions about capital gains? Any questions about anything we've discussed today?
Sam,
Yes, Dennis.
yeah. If once you're in, it is automatic renew every year.
Yes,
For the
once,
homestead.
that's a great question, Dennis. Once you have gotten homestead on your property, you will get a piece of mail from the county appraiser every year telling you that your homestead has been renewed. And it's your receipt. Usually it's I believe it's a green piece of paper, green card that comes from the appraiser. It's your homestead receipt for the year.
And do you have a number I can call to confirm for the
You
appraiser office?
would call the property appraiser in your county. Are you in Collier, Dennis?
Yes.
So you would just call, you go to collierappraiser.com and it's a 252 number. I can get it for you afterwards.
Okay, thanks. I can look it up. Thanks.
Okay. Other questions about homestead? I covered a lot. I know it's complicated, so feel free to shout them out. There's no such thing as a stupid question. Okay, we got a couple in the chat. So it's new taxes assessed on the purchase price, 1% on homestead and 1.5% on non-homestead. So then it depends on the county. I believe it depends where you live in the county. So for example, if you're in the city of Naples, I want to say the taxes are 1.1 mils, or 11 mils, which is about 1.1%. And it's higher on non-homestead. I wouldn't use 1% and 1.5%. Because the millage change, and again, it depends on your county. Okay, you're in Collier. Yeah, I would say about 1 to 1.5%, depending on the city versus the county. Elizabeth is asking, we sold our condo in Lee County. It was a second home, not homestead. Can capital gain exemption apply? Elizabeth, I get this question all the time. There are virtually no exemptions that I know of for second homes. If you have a second home, you're paying taxes. That's about how that works. Other questions? Marcia, you have a question?
I do. Sorry, I've got these darn doggies barking in the background. So I don't fish in the Collier County or Lee County pond. I bring the buyers to you guys. Yay. So my question is, Sam, because I work with people typically out of the country or from the Midwest, they're used to engaging an attorney. In the Illinois marketplace, it's an attorney state. So attorneys that work for a buyer typically have a predetermined price, as do attorneys that work for the seller, because there's some title work involved there. My question is there can you provide a schedule of fees, or give me an idea of what your costs would be for both buyer and sellers? Because I'm so impressed with every program I listen in on. I just learned so much from you, and I will never take the chance of trying to do this without an attorney.
All right. Well, thank you for the compliment. I do have a fee schedule and I will email it to you. Let me write that down so I don't forget.
Oh, terrific. Now I'm going to stop the barking dogs, and thank you all for letting me gush on Sam here for a second and ask for that additional information. Thank you, Sam.
Thanks, Marcia. I owe Marcia $10 for that. Just kidding. All right, we have questions in the chat. If a seller owns a home less than a year, is the capital gains rate different than if you were to wait 366 days? Josh, I am not a tax lawyer, but I believe the answer to that question is yes. You would pay capital gains at your ordinary tax rate if you held the property for less than a year. So I believe that's correct, but I would immediately direct your customer to a CPA to give that answer. I see people are looking for the fee schedule. All right, I will send out the fee schedule to the list. I'm seeing a lot of people ask for that. Does the property have to be homesteaded to get the capital gains deduction? Dean, it does not have to be officially homesteaded with the county, but it basically has to qualify as your homestead, because you have to have been your primary residence for 2 of the last 5 years. So it basically has to do that.
Sam?
Okay, so I'll send out, I see everybody posting. I'll send out the list. I'll send out the fee schedule. Don't worry about that. Yes, Elizabeth, I can help you with the trust. Call me separately. Okay. Last call for questions.
I have a question. Can you hear me?
Sure, Rebecca, go ahead.
Okay, I have my daughter who purchased the house in November of last year. She was not married. She got married. She and her fiance were on the deed together. They didn't change their license. That's the question, but they did have their utilities and everything in their name, and he was living in the house prior to the wedding without her. So and she can port her portability from her last house, but is there no way they can get exemption for this year?
It sounds like if they didn't have their driver's license changed over,
That's the biggie, huh?
that's the big one. I would go to the appraiser and I would fight for it
Okay,
as best you can. If you want to call me offline, and I'm happy to review the statute with you and talk to the appraiser, but the driver's license is a big deal. They
So-
usually will say no for that.
one more question. I have a lot of young married customers. My other question is, do they have to have their full name change for that, or does it matter? Like they can just go in their maiden name?
Oh, that doesn't matter. No, that shouldn't matter. It's the character of the property that matters on January 1st.
Okay,
So if you haven't changed your name yet, but your driver's license is changed over and all that sort of thing, then you should be fine.
okay, thank you.
Linda, yes, oh yeah, so everyone, I'm gonna send out slides, copies of these slides, and a link to my YouTube channel with the video on it in a couple hours.
Sam, Sam,
Yes, Angel.
yes, my question is, if somebody owns a property for 2 years and it's their primary resident, but they never knew about the homestead, when they go to sell at that point, would they be charged capital gains?
If somebody, so don't confuse state law with federal law. If you, for whatever reason, didn't register your homestead, didn't get Save Our Homes, you paid the taxes as they came due, but it was in fact your homestead, you lived there as your primary residence for 2 years, you can get the capital gains tax deduction. Federal law is different than state law. And if it's your primary residence, you would also get the asset protection that we talked about, paying your taxes, paying your contractors. You would also get asset protection going back 2 years, even if you didn't register it.
Thank
So
you.
it's only the tax savings that you're concerned about there.
Yep, thank you.
Yep. Okay, last call. I don't see anybody. All right, everybody, thank you all so much. Look for an email from me in a couple hours with slides and YouTube channel links and my fee schedule. Thank you all very much for your time today. And I will be on with a new webinar shortly.
Thank you, Sam.
Thank you all.